Number one, it says we protect compensation for expropriation. Now, even though if the state expropriate, takes away investment properties, but the investors will be ensured that there will be paid compensation, and only in certain circumstances that the state can expropriate. So expropriation means direct takings, okay, or direct takings, like taking by way that involves transfer of title. So this happened especially in 1970s when states newly became nation states and they want to move forward towards its own self-determination of economy. And they found out that there are many big companies in their country which are owned by former colonies, for example, okay, by Britain or by other external localities or nationalities. So what they did was, for example, in Iran, some Libya, some other countries, they nationalized the oil companies, or they nationalized foreign business. And because of that, even the title of the property was transferred, and that destroyed the ownership of foreign investment. That was why there was an uproar during that time, and that was why, due to the massive number of arbitration claims, there were special tribunals held for similar cases against the country. So expropriation is direct taking, like you change the whole name of the business to become your country's business. And then oil right now, because there's not so much of direct expropriation, what we are talking about is on indirect takings. So states sometimes they introduce regulatory measures which did not involve the whole transfer of title, but nevertheless it destroyed the economic value of the business. So by having that regulation, for example, the foreign investors were not able to manage or to use or to control the property in a meaningful way. And if they can calculate that loss, the foreign investors can also bring a claim against the host state under indirect expropriation. So there are many cases here I've mentioned. Energy disputes in the 70s, for example, Topco Libya American Oil Company, and other terminologies are nationalization, deprivation, dispossession, or outright physical seizure. So of course, when you talk about expropriation, you will be all talking about compensation. There are elements of expropriation as long as the country can show, if the country expropriates, but if it is because of legitimate reasons, and if it is not because of a result of discrimination, and if the country can provide compensation, then that is allowed under international investment law. But if this foreign investors can show that there was discrimination, no compensation was given, then and also if it is not because of a bona fide regulation, or not because of public interest, then the state will face compensation, okay, and likely the tribunal will decide it that it is an expropriation, a breach of standard of protection under international investment treaty. Okay, another important aspect of investment treaties, okay, is national treatment. Another one is the MFN, the most favored nation treatment. It comes together. The nation treatment is basically a guarantee by the host states that they will provide similar treatment to foreign investors as how they provide treatments to the locals. So, because, when states become new nation states, the tendency is that states would favor or give preferential treatment or give subsidies, to local businesses. And in the eyes of the foreign investors, this is discriminatory. So basically, when state entered into agreements, investment agreement, the state is actually agreeing to provide similar treatment to foreign investors. Of course, some of the treaties, they have exceptions in certain areas, certain sectors. Okay, for example, in Malaysia, we have infant industries, which we protect, and in those areas, the state will still give preferential subsidies which cannot be claimed by foreign investors. But it's very delicate in nature, so it has to be clear upfront. Okay. All right. As compared to the past, in the past, if you see in Latin American countries, in the past, before bilateral investment treaties were entered into, foreign investors, they do not want to be treated similar to the locals, okay? Because they feel that the locals' treatments were so bad at that time. And so they wanted the host states to give them international minimum standards of treatment under customary international law. So they want them to be treated like international figures which have international minimum standard. And that means giving more treatment as compared to the locals. Okay, but the narrative has changed today, because today with nation states, local treatment is in many cases better than the normal treatment given to others. So in the past, which I've mentioned just now, this is what we call as the Calvo Doctrine. If you read, then you will see the competing international standard before investment treaties were Calvo Doctrine against minimum international standard. Okay, all right. Okay, now we will look at what is happening around us. Inconsistent awards. Now there is a problem because arbitrations were given the mandate by parties. Okay, it is born because the parties give birth to it. Basically, it is not. We don't have a specific permanent court of justice for investment cases. So we don't have a specific justice system for that. But we have arbitral tribunals which evolve, or which is constructed, or which is established based on the disputes. All right. So the parties basically give powers to these arbitrators, and the job of the arbitrator is to decide based on the cases which comes in front of it. Okay, based under its mandate. So that is why we can't compare it to the court system, because it doesn't work like a court. So we cannot expect that the awards given by these arbitrators would be similar, okay, or would have some the doctrine of judicial precedence, for example. We don't have that in arbitral tribunals, and therefore what comes afterwards is, because it results to inconsistent awards. It's sometimes very strikingly different. Like, for example, in this case, the decision is towards the investor. In another case, the decision is towards the host states. And even the interpretations also sometimes differ. So because of this, the parties, the investors, because of this comes this concept, treaty of forum shopping. So you shop basically which would give you more favor. So sometimes for one subject matter, it is brought to several arbitral tribunals, and that causes what we call that as parallel arbitration. All right, another question which we ask, if you're doing PhD or master's or degrees, you wanna do further research on this, you can ask questions like, for example, is consistency a requirement? Do we really need uniformity? Okay, do we need a consistent interpretation? Of course, the proponents of the need of a consistent interpretation is that any law requires consistency, requires predictability. Okay, in the context of country, we want law which is predictable, so that we have confidence in the law. Okay, so that is why one proponent, a group of scholars say that it is jurisprudence. It has to be consistent. It has to have certain rules of standard rules which must be observed. And what is the preferred future? What we want is a consistent implementation of international agreed measures. Okay, because right now we see that the proponent towards a more predictable regime. I think that is the more taken view right now. Okay, now level playing field. The reason why treaties are entered into is for foreign investors to compete at the same level as everyone. Okay, especially when we talk about local investors, they want to have a level playing field with the local investors. That is why we have national treatment provision, and they also want to have level playing field with others, other nationalities, and that is why we have the most favored nation treatment principle. So the question then is, how do we balance that? Because states also need some room to regulate their own people, to inculcate or to grow their own produce own areas. And right now, there are also countries which are, rising. In the past, when you look at the Trump administration, for example, protectionism came back. Okay, basically, protectionism is you protect your country. Protect your country in the sense that it may restrict opportunities for others. Okay, so there is this discussion about state-owned enterprise versus multinational investments, and then the issues of harmful subsidy practices, market distorting behavior of state enterprises, regulatory states for host states, and etc. Right. So what is preferred in investment is competitive neutrality.